Mic is not working? Now it is, okay. Without objection, the chair is authorized to declare a recess of the committee at any time, and without objection, members of the full committee, not on this subcommittee, are authorized to participate in today's hearing. This hearing is entitled, Putting Investors First, Reviewing Proposals to Hold Executives Accountable. I now recognize myself to give an opening statement for 2 minutes. This is a legislative hearing on 6 different bills that are aimed at improving the accountability of public companies and executives. First, we have a draft bill that I've authored called the 8K Trading Gap Act of 2019. Right now, when there's a significant corporate event at a public company, the company has to disclose that significant event to the public by filing a Form 8K within 4 days of the event occurring. And there's been research from academics at Columbia and Harvard showing that executives do actually trade profitably in this 4-day gap. My bill would address this problem by simply prohibiting executives from trading during this 4-day gap. Next, we have a bill by Mr. Himes that would, for the first time ever, codify insider trading law. I think this is really important because up to now, all insider trading law has been developed by the courts and not by Congress. Mr. Himes' bill would set out a statutory definition of insider trading and would also reverse the harmful U.S. versus Newman court decision from 2014. Next, we have a bill by Mr. Foster, which would prohibit brokers and investment advisors from using forced arbitration clauses in their customer agreements. The bill would also prohibit public companies from inserting forced arbitration clauses in their company bylaws, which I believe is illegal already, but which could benefit from additional clarity. Mr. Green also has a bill to protect whistleblowers by clarifying that their employers can't retaliate against them even if they report suspected wrongdoing internally first, before they report it to the SEC. This would fix a recent Supreme Court decision which found that only whistleblowers who report wrongdoing to the SEC are protected against retaliation by their employers. Finally, we have 2 discussion drafts that would finally force the SEC to finalize 2 important Dodd-Frank rulemakings on executive compensation. I look very much forward to the hearing, our witnesses on all of these bills, and with that, the chair now recognizes the ranking member for 4 minutes for an opening statement. Thank you.
Thank you, Madam Chair. In a challenging global economy, America's capital markets are the key to our long-term economic growth. However, many of today's rules and regulations governing startups, entrepreneurs, small businesses, and investors were conceived in the 1930s and 40s. And parenthetically, a senator from Michigan, from Grand Rapids, part of my district area, Arthur Vandenberg was instrumental in that. Well, the telephone was cutting edge for Arthur Vandenberg, and times have definitely changed, and the U.S. wants to compete principally with China and win in a 21st century global marketplace. Then the U.S. needs to break free from old constraints and modernize our capital markets. We all know that small businesses are what drive the American economy. These innovators, entrepreneurs, and risk takers are critical for our country's economic prosperity. Small businesses make up 99% of all enterprises and help create more than 60% of the nation's net new jobs over the past 2 decades. Approximately 3/4 of all small businesses relied on financing in the last 12 months. However, nearly 70% of startups received less financing than they initially requested, while 28% received no financing at all. It's important to note that 80% of business debt financing comes from investors in our capital markets, not lenders at our banks. These numbers do not bode well for American innovation and business. The U.S. continues to witness a slump in the number of new businesses, which in 2016 hit a record 40-year low. The U.S. is only seeing half the number of domestic IPOs that it had 20 years ago, while the U.S. doubled the regulatory compliance costs a business must undertake. With more companies opting for private fundraising rather than the public market, the number of public companies has decreased to levels not seen since the 1980s, when the economy was literally half the size of what it is now, today. This means everyday investors on Main Street are missing out on valuable opportunities to invest in the next Microsoft, Amazon, Google, or other such companies. IPOs have historically been one of the most meaningful steps in the life cycle of a company. Quote-unquote, going public meant it was the ultimate goal for many entrepreneurs. You start a business from scratch, you build it up as a successful enterprise, and then open up for opportunity for the public to share in that success. Well, going public not only affords companies many benefits, including access to the capital markets, but IPOs are also important to the investing public. By completing an IPO, a company is able to raise much-needed capital for job creation and expansion opportunities, all while allowing Main Street investors the opportunity to have an economic piece of the action and the ability to participate in the growth phase of a company. For a myriad of reasons, the public model is no longer viewed as an attractive means of raising capital. Instead, small and emerging growth companies are choosing to go public much later in their life cycle or choosing not to go public at all. And many of them, I might add, are now not just millions, not tens of millions, hundreds of millions, but sometimes billions of dollars. And when we refer to them as unicorns, I'm not sure we can do that anymore. When you see the number of quote-unquote unicorns, we got a herd of unicorns out there, and at some point we need to allow these folks to go public. So we must work to change that trajectory. And speaking with the New York Economic Club, Chairman Clayton stated that, quote, regardless of the cause, the reduction in the number of U.S.-listed public companies is a serious issue for our markets and the country more generally. To the extent companies are eschewing our public markets, the vast majority of Main Street investors will be unable to participate in their growth. This potential lasting effects of such an outcome into the economy and society are, in two words, not good, end quote. While today's hearing is entitled Putting Investors First, Reviewing Proposals to Hold Executives Accountable, we can all agree that we should put investors first, but these 6 proposals, in my opinion, will do very little to truly protect investors. As currently drafted, these bills, in many cases, will do more harm than good by creating more barriers to capital formation and further deter smaller private companies from going public. In turn, ultimately limiting options and access for Main Street investors as well as Mr. and Mrs. 401k. With that, I yield back.
The chair now recognizes the gentleman from California, Mr. Sherman, for 1 minute.
The ranking member is correct that we need good capital markets, although I don't think that private equity is inferior, but perhaps the biggest problem with our public markets is so many investors making decisions based upon quarterly considerations or even in a quarter second buying and selling stock, and I can see how some companies would rather have owners that were more stable and more committed and allowed them to think in a 5-year horizon rather than a 5-minute horizon. The bills before us today will make our system fairer. Capitalism will not succeed if it's regarded as rigged. We need to prevent insider trading. We need to protect whistleblowers. As to putting something in the bylaws requiring arbitration, that is illegal under just about every state's corporate law. But some state will no doubt try to compete for businesses to incorporate in that state by lowering their standards even further. If we don't act to make it plain that you don't give up your right to sue just by buying stock, especially if you're buying stock under false pretenses, which is the nature of what you're suing for to begin with. With that, I yield back.
Chair now recognizes the ranking member of the full committee, Mr. McHenry, for 1 minute.
Thank you, Chairwoman Maloney. And look, our capital markets are decaying. The average age of listed stocks is getting older, and yet we have fewer stocks as an economy still grows. We have a problem with our public markets, and at the same time, we have what is really essentially the new stock market with the greatest upside potential in the path to prosperity, and that's happening in the private markets, places where only the wealthy and connected get a chance to succeed. This is happening while at the same time, our government allows people to invest in lottery tickets. We spend $80 billion annually as Americans on lottery tickets, yet we're preventing average everyday investors from actually investing in our economy, investing in America, and having the upside opportunity to make sure that they can grow with a growing economy and grow with prosperity. and have capital at work in our systems. We need to fix this, and we need to have a more vibrant capital market structure so that small businesses and everyday investors can succeed.
The chair now recognizes the gentleman from Connecticut, Mr. Himes, for 1 minute.
Thank you, Madam Chair, and I'm grateful for this hearing. And to the ranking members who have spoken, I'm hoping I can persuade you that a prohibition on insider trading is not, in fact, an argument about regulation, unless we want to contemplate regulating insider trading as opposed to forbidding it. And the reason I say that is because, remarkably, there is no statutory prohibition today on insider trading. We prosecute insider trading using fraud provisions in Sections 10B and 16B of the Securities and Exchange Act of 1934. This has led to a judicial mess. Just to give you a little bit of a flavor in my remaining 30 seconds, in August of 2017 in U.S. versus Martoma, the Second Circuit overruled its own 2014 decision in U.S. versus Newman, which was a case that was seen as a test of the Supreme Court's 2016 decision in Salmon versus U.S. on insider trading. All of this activity involved people's having their convictions overturned and a great deal of expenditure of judicial resources. If we're going to send people to jail for breaking the law, we should make that law very clear, and this is our opportunity to do so. Professor Coffey, thank you for being here. Ranking members, I hope I can persuade you of this and that we can create some clarity around something that creates a great deal of confusion and loss of confidence in our capital markets. And with that, I yield back.
Thank you. Today we welcome the testimony of a distinguished panel of witnesses. First, we have Professor John Coffey from the great city of New York, who is the Adolph A. Burley Professor of Law at Columbia Law School and the Director of Columbia's Center on Corporate Governance. Welcome back, Professor Coffey. Secondly, we have Melanie Lubin, who is the Maryland Securities Commissioner and is testifying today on behalf of the North American Securities Administrators Association. Next, we have Remington Gregg, who is Counsel for Civil Justice and Consumer Rights at Public Citizen. Last, we have Tom Quadman, who is the Executive Vice President of the Center for Capital Markets Competitiveness of the U.S. Chamber of Commerce. Witnesses are reminded that your oral testimony will be limited to 5 minutes. Without objection, your written statement will be made part of the official record. And Professor Coffey, you are now recognized for 5 minutes to give an oral presentation of your testimony. And thank you for returning to testify once again before us.
Chairman Maloney, Ranking Member Huizenga, other members of the committee, I am both happy and honored to be back here today. I've been asked to talk about several bills, all of which I favor, some of which need some significant tweaks, but I'm going to spend my time dealing with the insider trading statute. And here, I want to commend Congressman Himes for having supervised the drafting of a careful, balanced, and sophisticated bill that should serve as a model for the long overdue, I underline, long overdue effort to codify the law of insider trading. To date, as has been just noted, the law is entirely judge-made, and that has some costs. When you rely on judge-made law, it goes in 5 different directions. Indeed, there were 10 different circuits at least. It goes in many directions at once, and it can often be inconsistent. Frankly, this inconsistency has a number of problems. I have to note here briefly that I am not without some conflict here because I have consulted on this statute over the last several years. I am not the primary draftsman, but I do think this is a statute that's evolved carefully and should be looked at with a great deal of care. Now, that said, I want to take you through the backdrop of where we are today. There is general agreement that the law of insider trading has grown overly complex and technical. As a result, it's hard for the public to understand its logic or for practitioners to give advice to their clients. Even worse, when you depend on judge-made law, you are going to get disparities and inconsistencies. Let me just illustrate in a sentence. Since 2014, the Second Circuit has done an 180-degree about-face, from its decision in Newman in 2014 that very much interfered with the prosecution of insider trading, to its more recent decisions in Martoma in 2017 and Gupta in 2018, which has expanded the law considerably more than many of us thought it was going to go. But it's far from clear whether other circuits will accept these latest precedents or whether the Supreme Court will sustain them. All of this means it's a propitious time today for Congress to set standards. When Congress sets standards, there's less uncertainty. When courts make up the law on their own, they can follow any direction they want, confined only by whatever limits are in the statute. Okay, now I should also point out that I am a member of the Task Force on Insider Trading, which has been assembled by Preet Bharara, the former U.S. Attorney in the Southern District of New York. And although I cannot speak for that task force, we are focused only on insider trading, and I think we basically all agree that we need to move the law in the direction of greater clarity and simplification. In this light, the key virtues of the Insider Trading Prohibition Act that we have before us is, one, it is comparatively easy to understand, and two, it extends the criminal prohibition to reach clearly egregious conduct or misbehavior that is outside the law of fraud, but is instead a matter of computer hacking or theft or extortion or something else equally egregious, but not within the scope of Section 10b. Now, what does this new statute do? Essentially two things. One, it eliminates the need that the tippee pay or be promised some personal benefit by the tipper. This requirement has proved to be a very difficult obstacle, both because those payments can be hidden, and even more so, because there's a norm of reciprocity on Wall Street. That is, one hedge fund may tip another without getting any promise or any payment because it expects, pursuant to this norm of reciprocity, that it will get something in the future. Sometimes Wall Street resembles a giant favor bank, and in favor banks, you know that if you're going to make withdrawals and receive a favor, you've got to pay it back eventually if you want to get continuing access, and that's been going on. And you should understand the scale of these transactions. In Martoma, the most important recent case, the profits made and losses averted by Stephen A. Cohen, who runs something called SAC Capital, now shut down, exceeded $270 million. $270 million in just a day or two of trading. That's more than the mafia has ever done. Okay, that's the first point about the need to eliminate this personal benefit rule. The second point is there is some expansion of liability here, but it shouldn't be controversial because it only expands liability to cover other forms of egregious misbehavior. The statute 10b only precludes manipulation, deception, or contrivances. That leaves out computer hacking, theft, extortion, and all we're saying to make the law simpler here in this statute is that has to be a wrongful stealing or misappropriation of the information, which may not involve fraud. But there has to be a wrongful taking of the information, and then you can have liability.
Gentleman's time has expired, and the rest of your testimony will be part of the record. Ms. Lubin, you are now recognized for 5 minutes for your testimony.
Thank you, Chairwoman Maloney. Good afternoon, Chairwoman, Ranking Member Huizenga, and members of the subcommittee. Thank you for the opportunity to testify today. My name is Melanie Lubin. For the past 33 years, I've worked in the Securities Division in the Office of the Maryland Attorney General, serving since 1998 as the Maryland Securities Commissioner. I also represent Maryland within the North American Securities Administrators Association, known as NASA, where I currently serve as a board member and a member of the association's Committee on Federal Legislation. Since 2015, I've also served as the association's representative to the Financial Stability Oversight Council. NASA members include state securities regulators who for more than 100 years have served on the front lines of investor protection, safeguarding the financial futures of hardworking Americans and assisting local businesses and entrepreneurs in raising investment capital. NASA applauds the subcommittee on its decision to hold its initial hearings of the 116th Congress on proposals that explicitly place the interest of Main Street investors first. These investors are an engine of prosperity helping to drive our nation forward. When we put the interests of Main Street investors first, our capital markets, our economy, and our country all win. I will use the remainder of my statement to summarize NASA's perspective on the 6 legislative proposals that are the subject of today's hearings. First, NASA is very supportive of the Investor Choice Act of 2019 introduced by Representative Foster. The bill is a modernized and expanded version of legislation that NASA supported when it was introduced in 2013. Like the 2013 proposal, this bill will prohibit broker-dealers and investment advisors from including binding pre-dispute arbitration clauses in customer account agreements. These clauses deprive investors of the opportunity to pursue their day in court and instead force them into arbitration. Arbitrators are not instructed and do not have to follow the law. There are limited appeal rights and limited opportunities for discovery. The current bill goes further by prohibiting the use of pre-dispute arbitration clauses in relation to shareholder disputes with corporate issuers. We strongly support the bill, and we look forward to working with the chairwoman and the committee in passing the legislation this year. Second, NASA shares the committee's interest in creating a statutory definition of insider trading. An explicit definition will add greater clarity and consistency to this important area of the law. By proposing to codify much of the existing case law surrounding insider trading, the Insider Trading Prohibition Act is a major step forward. Third, NASA welcomes the introduction of the 8K Trading Gap Act of 2019 by the chairwoman. This bill aims to close the so-called 8K trading gap, which is the 4-day period between the occurrence of a material event and when the event must be publicly disclosed pursuant to the SEC's rules. We agree that there appears to be compelling evidence that this trading gap exists and that it unfairly advantages corporate insiders by enabling them to enter into securities transactions before the public release of that information. Closing this gap is a basic issue of fairness for retail investors. Fourth, NASA is similarly supportive of draft legislation sponsored by Representative Green entitled A Bill to Amend the Securities Exchange Act of 1934 to amend the definition of whistleblower. The bill would revise Section 922 of the Dodd-Frank Act to clarify that whistleblowers are protected by anti-retaliation provisions when they report alleged misconduct to their employers. This bill is a necessary response to the Supreme Court's 2018 holding in Digital Realty Trust v. Summers that only whistleblowers reporting directly to the SEC are protected. Last, two of the legislative proposals before the committee concern outstanding rulemakings to address executive compensation. Specifically, these bills seek to strongly encourage the SEC to complete rulemakings mandated by Dodd-Frank Sections 953A and 954. NASA strongly supported the Dodd-Frank Act. The preceding financial crisis had made it clear that the existing regulatory landscape required an overhaul to prevent another economic crisis and to restore the confidence of Main Street investors. The Dodd-Frank Act has largely achieved its goals, and where appropriate, Congress has taken steps to adjust certain of its provisions. Just as the 111th Congress was correct to reform our financial system in 2010, the 116th Congress is correct to insist that the SEC fully implement the law, including by completing these mandatory rulemakings. Thank you for the opportunity to testify before the committee. I will be pleased to answer any questions that you may have.
Thank you, Mr. Gegg. You are now recognized for 5 minutes for your testimony.
Good afternoon, Chair Maloney, Ranking Member Huizenga, members of the subcommittee. On behalf of Public Citizen and our 500,000 members and supporters, thank you for giving me the opportunity to testify. My written testimony lays out why we support all of the bills that we are discussing today, but for a few moments, I'd like to talk about the need to protect everyday investors from forced arbitration. Forced arbitration is a secretive, privatized system of justice. It deprives people of their day in court. There are no rules of evidence and almost no procedural safeguards, no requirement that the arbitrator follow law or precedent, virtually no ability for you to appeal if you lose, and guess what? You will lose. Forced arbitration is ubiquitous in consumer and worker contracts. According to Cornell's Alexander Colvin, when forced into arbitration, workers prevail just 21% of the time. According to the Economic Policy Institute, consumers prevail just 9% of the time. When corporations make claims or counterclaims, however, they win 93% of the time. So it's easy to understand why corporate America likes forced arbitration clauses so much. That's why Congress must pass the Investor Choice Act. It would protect everyday investors by placing firmly into law the SEC's longstanding policy, ensuring that everyday investors can continue banding together in order to vindicate their rights. It's hard for the retail investor, Mr. and Mrs. 401k, the everyday investor, whatever you want to call us, to bring a claim alone under the federal securities laws. If everyday investors cannot band together against corporate bad actors, we'll see what we see in the consumer and worker context. That is, namely, very few actually enforcing their rights and letting bad actors get off the hook. And is that what we want? Because what we'll get is less accountability of corporate wrongdoers, less incentive for them to do the right thing, more emboldened corporate malfeasors. At a time when more than 80% of all people, that's Republicans and Democrats, oppose forced arbitration, Congress and the subcommittee must protect everyday investors, protect their families, and safeguard their hard-earned savings. Thank you, and I look forward to your questions.
Our last witness is Mr. Quadman. You are now recognized for 5 minutes for your testimony.
Good afternoon, Chairwoman Maloney, Ranking Member Huizenga, members of the subcommittee. Thank you for the opportunity to testify today and for the subcommittee's continued focus on issues related to investor protection and capital formation. Business growth is a dynamic engine of American economic prosperity. Launching a business doesn't guarantee an outcome, but it provides an owner, employees, and their community with the chance to fulfill the American dream. Laws, regulations, and oversight provide the certainty for investors to allocate the capital for those firms to start and to grow. In other words, investors provide the gas for the engine to run. If a business is successful and can grow into a public company, we all benefit. When a business goes public, it reaches its apex of job creation, revenue growth, and wealth distribution. Yet today, we have half the number of companies than we did in 1996. Of the 2,700 businesses that went through the IPO process between 1996 and 2010, they created 2.2 million jobs, and their revenue increased by over $1 trillion. Today, the Hong Kong Stock Exchange outpaces any U.S. stock exchange in terms of the number of IPOs. Regional IPOs, those between $50 and $100 million, were prevalent in the 1980s and 90s, and they distributed wealth to retail investors in all the different parts of our country. Those IPOs today no longer exist. We appreciate the intent of the bills that are before us today, but we have concerns with several of them. Chamber strongly agrees that there's no place for insider trading. Insider trading neither benefits investors nor businesses. And we appreciate the clarity that Mr. Himes is trying to bring to this subject, since our insider trading rules are a conglomeration of regulation and court precedent. However, we have concerns with the bill, namely 3 of them. One, that this bill would treat insider trading as a strict liability crime. 2, that it would create an endless causation chain stemming from the action between the tipper and the tippee, and would actually outlaw 10b-5 plans, which are specifically designed to prevent insider trading. We also have concerns with the Trading Gap Act of 2019, though we understand the intent of the bill. Our concerns are that there is material non-public information which is actually not publicly disclosed, and furthermore, there is a cohort of officers who may not be privy of material non-public information as a 4-day decision window is underway. We also oppose the Investors' Choice Act of 2019. Securities class actions actually deprive investors of return. This bill would make it harder for investors to have their wrongs redressed. Arbitration allows them to have their wrongs redressed in a quick manner, and instead it would incentivize class action lawsuits and wouldn't provide investors with compensation. Securities class actions lawsuits are a top reason why businesses don't go public and why international capital sometimes seeks not to come to the United States. The Chamber also supports clawbacks as a tool to help redress wrongs and also to act as a deterrent. However, the bill that's before us today is over-inclusive. It includes many executives who have nothing to do with financial reporting, such as human resources executives. Furthermore, the SEC in its proposal failed to recognize its own recommendations for reporting, for financial reporting modernizations, which are necessary for clawbacks to be effective. We also have concerns with pay versus performance, though we do think ultimately this could be a good disclosure for investors. We believe for pay versus performance, for it to work, should be have a principles-based approach. However, the SEC proposal would in fact put short-termism on steroids. We also have concerns with the whistleblower amendment. We agree that it is important for employees to report to the company first or simultaneously with the SEC, And even with the digital realty decision, whistleblowers still have protections under the Sarbanes-Oxley Act. We do think that there's an important loophole in the Dodd-Frank whistleblower rules that should be fixed, namely that a criminal who's engaged in criminal activities can in fact become a whistleblower and seek a bounty and profit from a crime twice. We don't think that wrongdoers should be able to profit from their own wrongdoing. The current bills collectively, we believe, would create further disincentives for businesses to go or remain public. We are willing to work with Chairwoman Maloney and the drafters of the bills to address our concerns, and we hope we can come to a resolution on these issues, as well as address the reasons why companies are not going public. Thank you.
I thank you. I thank all the panelists. I now recognize myself for 5 minutes for questions. Ms. Lubin, I want to ask you about the 8K Trading Gap Act. As you know, SEC rules give public companies 4 days to disclose significant corporate events on an 8K. And sometimes companies actually need this time to prepare for the filings, especially if they're filing a complicated merger and they need to summarize all the terms. So there are legitimate reasons for giving companies 4 days to file an 8K, but is there any reason to allow company executives to trade during this 4-day gap? Wouldn't it be simpler to just prohibit executives from trading at all during this 4-day gap, as my bill would do?
Thank you for your question. There may be very valid reasons for allowing 4 days for a company to prepare a filing, but whether that delay should be 4 days, as is in the current rule, or something shorter, for example, the 2 days that the SEC had originally requested, can be open to debate. But the key point here really is that whatever the amount of time, there's no valid reason that insiders with knowledge of a material event should be able to trade during that time period. You know, when they're aware that they have market-moving information that's not publicly available to other investors, they really shouldn't be trading. Your bill is a straightforward approach to address the issue. The issue is about fairness and confidence in our capital markets, and the policies your bill would require and firms to implement would help level the playing field between insiders and Main Street investors.
Thank you. Professor Coffey, I want to ask you about Mr. Himes' insider trading bill. I personally think that a bill that formally codifies insider trading is long overdue, and I want to congratulate my colleague for doing such a great job on this bill. Can you talk a little bit, Professor, about why it's so important for laws like insider trading, which can carry criminal consequences, to be explicitly defined by statute?
As early as 1812, our Supreme Court said that common law crimes are unconstitutional. No one has ever created this crime. No question about it, the Supreme Court's upheld it at least 3 times. But we want the legislature to pass criminal statutes because courts are not in the business of representing the community and deciding what is criminal. And moreover, when you have 10 different circuits, you're going to get disparities and inconsistencies, and that's characterized the last 10 years. When you have a statute passed by Congress, there will be courts everywhere coalescing around the mainstream of that statute. Yes, there will be issues, but it will be clear you will have less disparities and less possibilities of people being surprised by new interpretations. So I think that's the core of the reason why you should prefer legislation of criminal law than judicial construction of it. This is not a question about whether insider trading should be unlawful. This is a question about whether Congress should do it or every individual judge should write in the blanks what he thinks works best. That's my analysis.
Thank you. And Mr. Gregg, as you know, forced arbitration clauses are common in brokerage agreements, but some people want companies to go even further by inserting forced arbitration clauses directly into company bylaws. I strongly oppose this, and I think it's already illegal under federal law. This would prevent shareholders of public companies from bringing class action lawsuits against the company for any security claims, including securities fraud. Can you give us some examples of class action lawsuits for securities fraud that have been successful for shareholders?
Well, there have been several, and what we have seen is that when everyday investors are able to bring those securities fraud violations, whether we're talking about WorldCom or Enron, they are able to bring significantly more or they're able to recoup significantly more when they're able to bring those claims. So there's no doubt that that we are able to see an increase of recoupment. I mean, right now, actually, Google shareholders are seeking to sue for what they have done, hiding systemic discrimination and harassment.
My time has expired, and I now recognize the distinguished ranking member for 5 minutes for questioning.
Thank you, Madam Chair, and I appreciate the opportunity to be here. And I would be remiss to say I would encourage the majority to give us a little more than 5 p.m. on Friday with a hearing notice to be able to be prepared, I think, to fully explore some of these issues. And I just would ask the chair to take that into consideration. She and I have a great working relationship. I want to continue with that. And I do agree with my colleague from California about his concern about quarterly statements that he was talking about. And this has been something I've talked about for years. When you have more focus on quarterly statements rather than and quarterly results rather than long-term thinking and long-term planning and long-term strategy, it does change that, and we've had various discussions about possibly changing some of those reporting requirements. I'd like to explore that at some point. And I do believe that this subcommittee at its heart is well summed up by saying investor protection, entrepreneurship, and capital markets, and we must preserve our edge, our advantage that we have as a country with the capital markets that we have. And Mr. Quadman, I'm going to direct a couple of questions towards you about that and about some of the challenges of being a public company here in the U.S. But I do also want to maybe touch quickly on that, on the 10B situation and Rule 10b-5 and have you address some of that. And I know my colleague from Connecticut had a dialogue with Mary Jo White at the time back in 2015, pursuing a line of questioning that he had, and her answer about whether there was an argument for codifying that. She said, and I'm quoting this, as I say, I think devil's in the details is maybe not quite the right expression to apply to this, but she continues, I think it is challenging to codify it clearly in a way that is both not too broad and retains the strength of the common law. And that was Mary Jo White in 2015, and the SEC has had some other discussions on that. So, Mr. Quadman, if you maybe touch on that first, and then I want to talk a little bit about IPOs as well.
Sure. So first off, I have tremendous respect for Mary Jo White. She was one of the foremost criminal prosecutors before she became SEC chair. I do think she's right that the devil is in the details. Our concern with the current bill here is that it's both over-inclusive and under-inclusive. And I raise the issue about 10b-5 plans because we have to think about 10b-5 plans as being almost like a blind trust that you can automatically sell shares according to a program without having any input into that. Both the insider trading bill as well as the 8K gap bill create problems with 10b-5 plans. I actually think the insider trading bill would actually outlaw them. So we need to be consistent with that, and I think that's something that should be addressed. In terms of the IPO issues, let me also put it in this way. We're beginning to, as a country, lose our ability to address these issues in a very forceful way. This committee has done a lot over the years in terms of the Jobs Act to address some of these issues, which has arrested the decline of public companies in the United States, but we haven't seen the number of IPOs go up. But when we start to look at the two issues that are really vexing it, one is research. Well, the research rules are being written by the Europeans through MiFID II, and they're going to go through a rewrite in 2020. And when we start to look at capital, Chinese venture capital over the last 2 years has become larger than American venture capital. So we've sat back for decades saying we've got the deepest, most liquid, most fluid capital markets. That is increasingly no longer the case, and we need to take the policy steps to correct that, as well as get rid of those obstacles which are preventing businesses from going public.
So, and I know I've got remaining about 1 minute here. Ed Knight, who's Executive Vice President and General Counsel of NASDAQ in New York, testified on the 5th anniversary of Jobs Act. Talking to various corporations, he learned that the primary challenge is not about going public, but it's oftentimes about staying public and being public, right? And can you maybe explain a little bit about that? And then if we're looking at IPO cost of $2.5 million to go public, and $1.5 million to remain public, how is that viable for these non-unicorn type companies? And so the challenge is there.
That's exactly the reason why we're no longer seeing those $50 to $100 million IPOs that I had mentioned earlier, the regional IPOs. The disclosure costs as well as the shareholder proposal pressures no longer make it one that it's viable for that model. The other thing you have to remember with the unicorns as well, that's no longer a cash-raising exercise. In some degree, that's a cashing out exercise. So we're no longer even seeing that as a funding mechanism and as a growth mechanism. We're seeing really as an allocation issue, and that actually harms the ability of the economy to grow.
Thank you. Your time has expired, and the gentleman from Georgia, Mr. Scott, is recognized for 5 minutes.
Thank you, Chair Lady. This is indeed a very interesting and timely hearing. There's nothing more important right now for our committee than to make sure we offer our consumers, our financial consumers, the absolute best in terms of investor protection. Professor Coffey, you were the only one of our panelists who mentioned the Newman court case. And the reason I say that is because I've just been given some very important information about the Securities and Exchange Commission has given this very pertinent information. They're saying we are warning that the Newman court decision will negatively affect the Securities and Exchange Commission's ability to effectively police and deter insider trading. So I think for this hearing to really grasp the meaningness of why we're here, we need to get some understanding of what the Securities and Exchange Commission is saying here. Could you enlighten us on this? And any of the other panelists who are there, let's try to find out, because these are the folks that have to police investor protection. And if they're saying from the Newman case that there is a very serious problem, we need to find out what they're saying. So could you enlighten us?
Certainly. The commission is, I think, clearly right. I should add that last year, 2 years ago now, the Supreme Court partially overruled Newman, but they left a large part of it to be still a barrier. Now, in light of Newman, the Southern District of New York had to reverse something like 15 convictions that it obtained, and the SEC didn't feel it could sue because you had to prove under Newman not only that a remote tippee knew that there had been a personal benefit paid by the original tipper to the original tippee, but also that there was some expected benefit that was going to go back the other way, that there was a reciprocal benefit that had been promised. It's very hard to know that. What's more, it gave rise to a natural defense technique. Don't ask, don't tell. If you don't ask how the person knew it, you didn't know whether or not he had gotten this in return for paying a personal benefit to the tipper. It was an impossible burden to put on the prosecution.
Okay, so what I want to get to here is that we have Mr. Hines's bill, of which I'm supportive of. Are we addressing that appropriately enough? Is there something we need to do so that we're responding to the warning of the Securities and Exchange Commission on this?
Good question, and the answer is definitely, because by abolishing the personal benefit rule, that's the key provision that Newman elaborated and made a major, major obstacle by saying not only there had to be a personal benefit, but everybody in the remote chain of tippees had to know exactly what that benefit was and had to have some awareness that there was a promise going back the other way. So The Himes bill will definitely solve what remains of the Newman problem, although the Supreme Court already has partially reversed Newman.
Okay, Ms. Lubin?
So I think it's a very helpful bill because as a career civil prosecutor, it helps us when we bring cases, and it helps people when they're trying to comply with the law to know what the parameters are, and not have to worry about, I'm sorry.
No, go ahead. So our Himes bill addresses that to your satisfaction. Mr. Gregg, are we on target here? We take care of that?
You're on track.
All right, Mr. Corman,
Yeah,
we hear from you.
Mr. Scott, as I outlined in my opening statement, we have 3 major concerns with the Himes bill. We also have a couple of concerns with the AK GAP bill. We agree, though, with the intent of both bills because we believe that insider trading should be prohibited. I would also say, too, with the AK GAP issue, there are 2 executives with Equifax who have been charged with the crime because they were trading during that 4-day period. So I think we would like to maybe address some of the issues, particularly with the Himes bill, where we can get it right because we think at some points it's over-inclusive, other points it's under-inclusive, and we need to get it right.
But I want to make sure that you're clear that we, with the Himes bill, definitely takes care of the Securities Exchange Commission that was brought out in the Newman court case.
Part of the fix that we see there, we think actually deals with the mens rea issue in a wrong way, and that's part of the issue that we want to talk about.
Okay, thank you.
This time has expired, and the chair recognizes the ranking member out of order.
Well, thank you, Madam Chair. I appreciate the point of personal privilege. I just wanted to welcome a couple of families from West Michigan who are visiting here, the Kuiper and Davies families, teachers back in the district and their kids. It's very exciting here in the Financial Services Committee, kids. I promise you, at least at some point in life, it will become so. But they, along with so many other people, are here in Washington, D.C. enjoying spring break. So I appreciate that opportunity to introduce my friends. So.
Well, welcome to the committee. The gentlewoman now from Missouri, Ms. Wagner, is recognized for 5 minutes.
I thank the chairwoman. Mr. Quadman, I've got a number of questions here, so please, if you could briefly discuss how the Jobs Act of 2012 has helped American companies and startups reduce costs, gain access to capital, and grow as public companies.
You know, it did a few things. One is, you know, the road show and testing the waters provisions has actually allowed investors and businesses to go out and have discussions and test things out ahead of time, which have been helpful. It has also allowed for certain on-ramp provisions to allow companies to grow into certain disclosures rather than having to have the burden of the cost right up front.
Despite some of the clear benefits that the Jobs Act of 2012 had for startups, what are some of the regulatory concerns that startups will still have today?
Well, we're talking about some of these here today. Securities class action lawsuits are a very big reason why companies don't go public. Proxy advisory firms are another reason, and in fact, the pay versus performance provisions here would actually would entrench the proxy advisory firms further without any oversight from the SEC. There have also been some auditing issues coming out of the PCAOB that have caused some problems, but those 3 things combined are amongst the reasons why we're not seeing businesses go public.
With the bipartisan capital formation bills that originated in this committee and passed the House last Congress as the Jobs and Investor Confidence Act build on the success of the 2012 Jobs Act for small and emerging companies, do you believe?
Yeah, and that bill passed with over 400 votes. Those were small incremental steps, as we were calling it, a Jobs Act 3.0 at that point, that would again incrementally help reverse that situation.
What do you believe are the biggest deterrents to companies going public?
We have an out-of-kilter shareholder proposal process. We have proxy advisory firms that are running rampant. We have a number of other issues in terms of disclosure costs. We have a disclosure system, we have to really talk about it, that's rooted in the 1930s. It's no longer it doesn't serve the needs of a 21st century economy. As I've said before, when companies have to pick an historic stock price on one date every year, when you can figure, and I can tell you what the stock price of Alcoa was on June 17th, 1972, it shows how out of date that system is, and then start to replicate that hundreds and thousands of times. So there are obsolete disclosures we need to address.
And what size companies suffer the most from the regulatory costs associated with going public?
The smallest. And that's the reason why I said we're no longer seeing the regional IPOs, and that's why you're seeing companies grow to be unicorns, and then they're going to take their time to decide if they want to go public or not.
And that's my concern, is the small companies, those startups, those emerging growth companies. Would the bills discussed in today's hearing create additional requirements on American public companies, adding to their regulatory compliance costs, do you believe?
Yes, they would, and they would be significant. And one other point, just to go back to your last question, just to hit one other point there. When unicorns go public, retail investors can't get the benefits of that IPO. It was the smaller IPOs that allowed the retail investor to reap the rewards. That's why you saw, people, everyday people, getting wealth distributed their way. We're now seeing a closed system where certain large investors reap the rewards, and the retail mom-and-pop investor is left in the dust.
As everyone knows on this committee, and I certainly have expressed over and over again through the Reg BI proposal and the long fiduciary struggle we have been through between the SEC and the Department of Labor, I care deeply about those low and middle income investors in my district and across the country. So none of the proposals discussed today would apply to private companies. So would these increased compliance costs for public companies deter private companies from going public?
Yeah, those private companies won't go public. And I think what we have to recognize, we still have the gold standard when it comes to public capital markets, but we're beginning to fall behind. Both Chairman Clayton at the SEC and even Chairman Dunkey at the PCAOB are trying to address these issues, but it's very important for Congress to set the appropriate policy objectives that we start to reverse these trends.
And to go back, just put a fine point, how does a company going public not only benefit the economy in terms of jobs, but also America's Main Street investors?
Correct. Well, one of the things that we're also seeing with this calcification of the IPO process, 50% of all business startups now are occurring in 20 counties, representing 17% of the American population.
Wow. Thank you. My time has expired. I yield back.
Okay, the gentleman from Connecticut, Mr. Himes, is recognized for 5 minutes.
Thank you, Madam Chair, and thank you to the panel for your comments on my insider trading bill. I am determined to get this through with bipartisan support. I am telling my Republican friends that this is really not a regulation bill. This is a question of making sure that the activity that we all agree should be illegal is in fact illegal because the Congress passes a law making it illegal rather than ongoing interpretations by judges. Mr. Quaterman, in my effort, because I know you raised some objections in my effort to clear up possible objections to my bill, you raised 3 objections that I'd like to ask you about. You said in your testimony that my act would establish, and I quote, insider trading as a strict liability crime in removing any scienter requirement. I had to review the second year of law school I never took as a non-lawyer on scienter and mens rea, but I want to read to you from Section 16A of my proposed legislation that reads that one is liable only if such person knows or recklessly disregards that such information has been obtained wrongfully. So that looks to me, and I am told that this is the very standard set by SEC versus OBIS for scienter. And this, by the way, is repeated back on pages 4 and 5 of my bill. So my question is, why do you think that the bill establishes insider trading as a strict liability crime?
Because we think that some of the efforts made in the bill to address the Newman issues, and I understand what you're trying to do there, take away from a mens rea requirement. Our reading of it was different than yours or maybe Professor Coffey's. Which is why we thought that that impacted mens rea. Now, I'd be willing to have a further discussion with you offline about that because we think that you do need a mens rea requirement in order for insider trading legislation to be effective.
But isn't knowing or recklessly disregarding, isn't that the definition of mens rea?
Well, it's the measurement of intent that the court would have to find, and we don't necessarily think when you take a look at the bill in total that it gets there.
Okay, can you be more specific and point out a line or a section you think is problematic in that regard?
What I can do is I can maybe get back to you on that, but it was the reading of the total bill and in addressing the Newman issue that we felt was affecting the mens rea requirement.
Okay, I'll follow up on that
Yes.
because I think we were pretty clear about knowledge and intent here. But nonetheless, I'm not a lawyer, so I'll be deferential on the question. I assume, by the way, that if we can satisfy each other on this point, this also deals with the concern you had, your third concern on 10b-5 plans, right? 10b-5 plans are just plans that predetermine a number of shares to be sold at a predetermined time. So if I am not acting wrongfully under my bill, as my bill defines it, that presumably wouldn't impact 10b-5 plans. In fact, only if you altered a 10b-5 plan would you be liable, I think.
Well, clearly, if you're altering a 10b-5 plan and you have information, you're certainly in a gray area there. But if you take a look at the two actions separately, right? If you are in possession of knowledge, right, that is not public, and you have a 10b-5 plan going on, whether or not and let's say you're not even addressing that or trying to change that, under our reading of the bill, you actually couldn't go forward with the 10b-5 sales. Now, I think what that would do, we would have to do is tweak the language somewhat, that if you make the 10b-5 plan, almost consider it like a blind trust, even if that member if that person has knowledge and they're not affecting the plan in any way or not adjusting the plan in any way, that you would then allow the 10b-5 plans to move forward.
Okay. Obviously, the intention here, in fact, if you have a 10b-5 plan, by definition, you've said, I will sell this number of shares on this date without knowledge. And so this feels to me like a solvable problem.
Yes, I didn't think it was your intent to deter
course
10b-5 plans at all. As a matter of
Yeah.
fact, I think you would want to encourage them.
Yeah, absolutely. So I will follow up on your offer for specific language because this feels like a solvable problem. In the last 40 seconds I have here, let me just give Professor Coffey an opportunity to reflect on the exchange we just had.
I think it's been ignored so far that the Himes bill doesn't stand by itself. There can be no criminal prosecution under the Securities Exchange Act without it running through Section 32A. And 32A requires that for a criminal prosecution, the mens rea level is willfully. Your standards are the standards for civil liability in your bill, but a criminal prosecution would require that the prosecution show that you willfully violated this rule, and that means really a corrupt purpose or intent. A technical violation won't create criminal liability. So I don't think the mens rea problem is really any different here than any other criminal prosecution, all of which run through Section 32A.
Thank you. Professor, Mr. Quadman, I'm going to take you up on your offer for some written suggestions on how to address whatever concerns you have. And with that, yield back.
The gentleman from Arkansas, Mr. Hill, is recognized for 5 minutes.
Thank the chair. Thanks for holding this hearing. Thanks for bringing this fine panel before us. Could we put up my graph, whoever's doing that? Not that one. That's a good one. That one. Thank you. So we've been talking today about public companies, and of course there are 50% fewer public companies than when I graduated back in 1979 and went into corporate finance. And this chart in the golden yellow line at 7,000 back in 2000 shows the last peak in public companies at the height of the dot-com boom in small public offerings. But it's been flat here since the financial crisis of companies public, and that's despite great efforts on a bipartisan basis here to enact the Jobs Act legislation. And we've seen emerging growth companies, but we see this private equity line in blue has continued since 2000, upward and upward. So, Mr. Quadman, I'm curious, you talked about some of the things, but I'm curious if not only the cost of being public, you talked about litigation costs, you talked about compliance costs within a post-Sarbanes-Oxley environment. We've exempted a lot of that burden through the emerging growth company definition. We've moved the market cap size up. And so I'm curious, what else is contributing to companies not going public? And I wonder if it's a consolidation in the investment banking community where there are fewer companies, taking smaller companies public because they really can't really make a profit making a market in small and mid-cap companies now as they could years ago. So has Reg NMS or some of the capital market systems impacted the ability to go public?
So yes, and I would also add some others with that. First off, I would say with the private equity line going up, it's important for us to also have vibrant private markets too.
Right. This is not a criticism of private capital, obviously.
No, we need to have both. I think you're right, Reg NMS, market structure issues which remain unaddressed, even issues, let's say, with the Volcker rule, which affect the ability of banks to go, or for businesses to go into the debt and equity markets. You have a combination of all those that it starts to make public capital that much more expensive versus private capital.
Right.
And so, yes, you're correct. We've dealt with some of the disclosure issues and are dealing with some of them, but it's the cost of capital that is also driving this. And that's why I mentioned the Chinese venture firms, capital firms before, because they're also beginning to expend a lot of money here in the United States. And it's because of that disparity in the cost of capital that's driving this.
Well, I think it's just something for all of us on the committee to be concerned about. Would the package of capital formation bills that we called informally Jobs 3.0 that we passed before the House last September that Chairman Waters and former Chairman Hensarling worked on together, would they be at the margin beneficial to this?
I think they would be, as I said, incremental steps forward. I think the two problems, as we've been talking about, liquidity in terms of the cost of capital as well as the lack of research with smaller companies, I think Jobs Act 3.0 start to take steps to help reverse that trend. The other thing I would say with that chart, when you take a look at the public company side, when you see that slight bump up and then the flattening, that's when the Jobs Act came in. So when you take a look, and you even went back to 1996, number of public companies went down every year up until then. So what we need to do, and this is what the intent of Jobs Act 3.0 was, to start to have the curve start to go back up again rather than just being flat.
Right, good. Thank you for your work on behalf of the Chamber for that. I was reflecting on the arbitration bill, and in my view of arbitration, having been subject to it and part of it for 3 decades, is that we have so many small owners, and we have 4,000 firms and 160,000 different, or 600,000 registered people, that this was a way to speed access to a just award. In my reading of the statistics, about 44% of FINRA arbitration claims result in a damage award to a consumer, so it doesn't seem like it's tilted anyway there. We have public members of those panels. And class actions are exempted. You're not eligible for arbitration if there's a class action about a stock. So is this helping lower costs for investors and the investing public?
Arbitration helps lower the cost. It helps for speedy rewards. I would also say, too, when you take a look at securities class action lawsuits, $50 billion is given to the class action bar as a result of that. That actually comes from the investors' pockets. Yeah. I think people don't actually make that connection. And even with the FINRA arbitration awards, there's a significant number of FINRA arbitration cases that are settled before they even go to the arbitration process.
Thank you, and I yield back.
So the gentlewoman from Iowa, Ms. Acne, is recognized for 5 minutes.
Thank you, Madam Chairwoman, and thank you to the panel for being here today. I appreciate it. Absolutely appreciate all of the proposals that we're reviewing today, but I'd like to focus a little bit more attention on 2 of the bills regarding executive compensation. As I'm sure everyone here is aware, Wells Fargo's CEO just announced his retirement. However, considering that despite all of the scandals that we've seen, he made more than $50 million as a CEO, including $2 million in bonus just 2 weeks before he retired. I think we should all be concerned about if his performance was worth that pay. So my first question is this to the panel members. This seems to me like exactly the problem with investors and public not having full disclosure about the relationship between a company's performance and their CEO's executive pay. Professor Coffey in particular, considering that Dodd-Frank was signed into law almost 9 years ago and the rule was proposed 4 years ago now, why has this process taken so long?
The SEC has gone very slowly the last 2 years, And you can speculate why, but it's not just the ratio of performance to payment, it's the clawback rules, because there are lots of reasons why there may be clawbacks yet from all the senior management, but there is no mechanism for enforcing it. So I'm very much in agreement with what you're saying, but I would put a little bit more weight on clawback rights. If you have been there when there's been a major restatement, a major scandal, and you've had to pay it all back to the government, I think your bonuses should be clawed back, and that can't happen without more rules than we have.
Okay, appreciate that. So, Mr. Gray, can you talk about why it's important for the SEC to have these common sense rules for the clawback of improperly obtained incentive compensation?
Well, I think it's pretty simple because there are two important reasons. Number one is the link. Shareholders should be able to know what's the link between performance and compensation. That's just simple information that they should know so that they can judge for themselves if someone is actually being compensated well or for a good job or a poor job, or if they are being wildly compensated for no apparent reason. And the second is transparency, that they have a right to know this information. I'll just put this out there that, for example, last year for the compensation of Boeing executives, part of the Form 14A said that one of the metrics for executive compensation was reducing costs. So that is something that I think shareholders would want to know, that reducing costs is something that went into the compensation of Boeing executives, given what's happening right now at Boeing.
Appreciate that. Thank you. Any other comments on either of those questions from the group here?
Well, I would just say, first off, in terms of Wells Fargo, number one, there are a number of different investigations that are going on that haven't been concluded yet. Number two, there haven't been allegations that Mr. Sloan has necessarily done anything wrong as of yet. Furthermore, I would say with the pay versus performance issue, it wouldn't actually get to the issue that you're talking about, because pay versus performance on the SEC proposals actually dealt with a total shareholder return. And I would actually say, too, that's a misnomer, because if you take a look at a company that's in a bad way and they have to go out and hire a new CEO, their TSR wouldn't look right. But you know what? They're having to go out and hire the talent to turn the company around. So under the proposal the SEC proposed in 2015, before this SEC, that was not a workable proposition, which is why we've said it should be a principles-based approach. I would also say, too, if you take a look at companies, they have say-and-pay votes. And almost in every company, say-and-pay votes are passing by 80 or 90% from investors, in which case investors are saying, we have either the right person on board and we're paying them what we should be paying, and investors have not walked away from that.
Ms. Lubin?
I think these proposals are important because they provide increased transparency to investors. So they could understand how executives are compensated. They could understand how much risk an executive is willing to take to drive up the stock price in order to make whatever bonus they're going to make based on their compensation arrangements. So it helps an investor understand, am I looking at a company that's going to be steady, do what they need to do, or am I looking at a company to invest in where they're going to do something that's really risky in order to drive the price up so the CEO or someone else can get their bonuses?
Yeah, appreciate that. Well, I can tell you, Mr. Quadman, I can tell you as an investor, I certainly don't feel that the information that I need is very transparent to certainly make any vote as an investor in any company. So thank you so much, and I yield back my time.
The gentleman from Guam, Mr. San Nicolas, is recognized for 5 minutes.
Thank you, Madam Chair. I first wanted to discuss the slide that was up earlier because, I had some observations on it, and those observations are based on me actually being in the financial services industry as an investment advisor with my Series 7 and 66 licenses. We had to weather two major occurrences that I think were primarily responsible for the actual shifting down of the number of companies that were public. We had the financial crisis most recently, and prior to that, we had the bursting of the dot-com bubble. And if we pull up that slide, you can see that both of those downdrafts were as a result of those two crises. And so we need to be very clear of the fact that if we're going to be talking about what's impacting a number of public companies, in both of those instances, what impacted them the most was recklessness. recklessness in the industry. And so, Ms. Lubin, I very much appreciate your recent comments about how increased transparency to investors is a good thing. Another thing that I think we need to take away from this chart is the fact that while we do see an increase in private equity relative to public companies, we also need to understand that a lot of the way small and medium-sized companies are going public these days has changed. In the past, they used to go public and hope that their business model, whether it was profitable or unprofitable, especially in the dot-com bubble, they were hoping that that was going to be sufficient for them to raise public capital. Today, a lot of companies are first relying on private equity to be able to finance themselves during their growth phases, when their earnings are inconsistent, and when they're still trying to get their bearings on their business model. And that's important to understand because when we're talking about, going public as a company, you got to meet quarterly targets. You got to meet earnings expectations, and you got to show almost a continuous trend of growth. Otherwise, your stock prices are going to suffer. In private equity, you don't have that kind of baggage. And so a lot of our small and medium-sized companies that are under the private equity model right now are still trying to work out their business models and smooth out their earnings history so they can get to a place where they can go public. And while oftentimes that's a cash-out event for the private equity that's invested in those companies, it hasn't turned out to be necessarily a bad thing. Our markets are at our historic highs at this point. So perhaps the evolution of the way companies go public has changed, and it's not necessarily a reflection of the market being overregulated. I did have a concern with respect to the arbitration component, having worked in the industry, and I wanted to pose this to Mr. Gregg. And that is that while I can understand that we want to always ensure that everybody has the ability to file the lawsuits and the class actions, I also, as an advisor and also as a shareholder, I would receive notices from these law firms that are just circling, looking to file whatever class action they could against a company and then try and settle those class actions in order to just, get their check and move on. And so I wanted to ask, while there is a strong case to be made for allowing for class actions and for lawsuits and doing away with arbitration, how much frivolous class actions and frivolous lawsuits do you think might have been avoided with arbitration being something that was in place? And perhaps arbitration might not necessarily be a bad thing altogether. Perhaps it's just something that needs to be more tilted towards balance for the consumer. So if you can provide some insight into that, please.
Well, thank you for the question. I would say, number one, every person should have the opportunity to enter into arbitration post-dispute. Knowledge is power, and so if you have a dispute and you then decide that this is the best thing for you, you should be able to do that. We're talking about pre-dispute. We're talking about, the fine print of your app, so that you never even see that you're being forced into it. So that would be number one. And then number two is to the question of litigiousness. Our courts, the Supreme Court has ascribed a very high bar over the last few years in order to get into court and stay in the court, the heightened plead standards on the Iqbal and Twombly. And so it's very hard to, one, get into court and two, stay into court. So I would respectfully disagree on that claim that there would be a lot of litigation because our courts are dealing with that, and the Supreme Court has already dealt with that in terms of our pleading standards.
The bar may be set higher, but that's the bar to get into court. Just the mess of having to go through the process of getting there and dealing with the challenge and the accusation and the reputation risk and the public scrutiny, those all incur cost to a company that they all sit down and they factor based on what decision they're going to make with respect to whether they're going to just settle the suit or move forward and actually climb over that high bar. And so I just wanted to have the dialogue because it's something that I'm trying to reconcile given my experience. Thank you, Madam Chair.
The gentleman from Illinois, Mr. Caston, is recognized for 5 minutes.
Thank you, Madam Chair. Thank you all for being here. I'm going to try to be a little bit scattershot and hit hopefully all of you here before this is done. I want to start with some questions about my friend Congressman Foster's bill. Professor Coffey, in your opinion, what impact would permitting forced arbitration clauses in corporate documents and IPO documents have on an investor's ability to recover damages for securities fraud?
In my view, investors will not exercise that. People have pointed earlier to FINRA arbitration. I think I'm the only person in the room who's been a FINRA arbitrator, and I think it does work but that's against the broker, and that's being run by a basically government-sponsored organization, FINRA. If you just put this in the corporate charter, there is no one there to establish the mechanism and make it fair. And what happens with most arbitration procedures is that the consumer, or here the shareholder, never exercises arbitration, and neither wins, neither loses, just doesn't try it. And I think that's what's likely to be the most probable consequence of putting it into the corporate charter.
Thank
Why
you.
don't I turn it over to this?
Well, the second question is for Mr. Gregg. I have negotiated far too many contracts in my prior career outsourcing energy assets in the industrial space. We often included either mandatory arbitration provisions or waiver of jury trial provisions. We did that between two very sophisticated, heavily lawyered up companies. I note that in Mr. Foster's bill, he provides the option for investors to choose to select arbitration or not. In your view, and if there's no black and white line, that's a fine answer, are there conditions where you think it's appropriate to defer to mandatory arbitration? Do you think it's always negative? Are there conditions where you think it's appropriate to have voluntary choices, or do you think we should stay as we are right now?
Well, we definitely shouldn't stay where we are right now. I think it's important. So the SEC has said that their longstanding policy is it's contrary to the federal securities laws, but to force people into arbitration, at least in the class action context. But what we're seeing is a push by corporate entities very hard to try to get the SEC to change their longstanding policy. So it's important for, I believe, this body to say unequivocally that they're protecting investors. Again, if people want to go into arbitration after an event, after a dispute, that's fine. The point is, what we have right now is people being forced into a system that they know really nothing about. In a nursing home, when you're seeking employment, you get 10, 15 documents, and they say sign here, 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 and you have no idea that that you're even being forced into something until there is a problem. You've been discriminated against. There is wage theft. So first and foremost, it's about transparency and ensuring that every person understands what they're entering into.
Okay, thank you. My next question is for Ms. Lubin. There's been a lot of discussion here today about what to make of this decline in public company listings, and I think the implication that several have raised that this says something about the regulatory burden of going public. I'd ask unanimous consent to enter into the record a Harvard Law article from May 2017 looking behind the declining number of public companies. And I want to specifically just call out three things from their article. They note, number one, that there are more foreign companies doing cross-border listings than ever before. Number two, there is a significant decline in delistings in public markets in recent years. And number three, they describe, I'll give the quote here, the growth in alternative financing methods has extended the private financing stage of the investment cycle. Excuse me, got a frog in my throat. And they conclude that the trend towards IPOs of higher quality, more sustainable companies is likely to benefit investors. So essentially what they're saying is, yes, there are fewer companies listed, but we have, between private equity, master limited partnerships, all these vehicles that have emerged. We just have a more diverse financial environment than we used to, and that's the result of it. Now, these are two pretty different views. There's one view that says the decline in IPOs is because of regulatory burden that hurts investors. There's another view that says investors are actually better off because we have more stable countries that are not delisting and more options. Do you have an opinion on which of those two extremes is closer to the truth?
Thanks for the question. In all the years I've been looking at these things, and I've been looking at them for a lot of years, there has been a decline in IPOs, but there's been an increase in all the other mechanisms before somebody wants to go public. And I think it's served investors well. In the early stages, venture capital stages, private placements, things like that, it's a much riskier stage and isn't really the kind of thing most advisors would advise a Main Street investor to jump into. So it's appropriate for those things to stay private, and then when they really are matured, then go public and then subject the Main Street investors' monies to those kinds of offerings.
Okay. And I had a question for you, Mr. Quadman, and I apologize, but I believe I'm out of time.
Time is up. Okay. Thank you. And now the gentlewoman from New York, Ms. Ocasio-Cortez, is recognized for 5 minutes.
Thank you. Thank you very much, Madam Chair. I would like to seek unanimous consent to submit to the record a New York Times reporting on arbitration entitled Arbitration Everywhere, Stacking the Deck of Justice. What we're seeing here, and I'm interested in the interplay between everyday people, everyday consumers, and arbitration clauses. The arbitration clauses that are tucked in everywhere from whenever you sign a credit card or a debit card. It says here, even in the report, on page 5 of a credit card contract used by an American Express, beneath an explainer on interest rates and late fees, past the details about annual membership, is a clause that most consumers probably miss. It says that the company may, quote, elect to resolve any claim by individual arbitration. Now, a lot of folks, to just clarify for the general public what an arbitration clause is. Arbitration clauses have been used, would you say, Mr. Gregg, that arbitration clauses have been used to circumvent the courts on a wide range of issues?
Correct.
Of potential misconduct?
Yes, so it's used against workers when it relates to sexual harassment or discrimination, wage theft. It's used in the consumer context when you have a dispute over your credit card or student loans.
So if you're a company and you tuck this clause into virtually anything that you can make an employee or a consumer sign, whether it's a credit card agreement, whether it's an employment contract, you can essentially absolve yourself from almost any form of corporate misconduct. Is that correct?
That's correct. That's what will happen.
I find this extremely concerning that you can almost, before misconduct happens, already waive your right to seek justice in court. In fact, William G. Young, a federal judge in Boston who was appointed by President Reagan, said, business has a good chance of opting out of the legal system altogether and misbehaving without reproach. Would you agree with that, Ms. Lubin?
I think thank you for the question, and I think the way that pre-dispute arbitration clauses have developed in the brokerage business, that's what's happened.
Thank you.
I'm
sorry, I just have to reclaim my time very quickly. But thank you. So you would agree?
Yes.
Mr. Gregg, I'm interested here in the wider impact. We're talking about not just issues of discrimination and worker abuse, but even on a macro level or potentially macroeconomic level. In fact, a federal court now is allowing a lawsuit by Exxon investors to move forward. Investors claim that Exxon knew and kept secret for years internal reports showing that they knew climate change and they knew that climate change was real, and that the fossil fuels and their role in producing fossil fuels contributes to the role of climate change. Yet, they undertook a misinformation campaign to hide those internal findings and reports, including lying to their own shareholders. Mr. Gregg, are you familiar with this lawsuit at all?
I am.
So I have a question here. If we do nothing about forced arbitration and allow this practice to continue, could this mean that information about how companies are deceiving the public about issues like climate change or any other could remain hidden from the public and public scrutiny?
It could if we don't pass right now we can, currently shareholders are allowed to go together, to band together in a class action, but there are attempts to stop that, so that's why it's important to pass laws to protect.
So you would recommend that we support the legislation that we're entertaining today on investor protection to make sure that shareholders can be protected as well?
I would, because if we don't do that, and the SEC reverses its policy, for example, then systemic issues would be able to be hidden, and you would never be able to find out about these things.
And even on a macroeconomic level, beyond the justice of it, beyond making sure that shareholders that have been damaged by this deception and misconduct can recoup their costs via class actions, do you think that this has overall consequences for market integrity? So much of our macroeconomic and to make sure that we have a sound market depends on us trading on the truth. And if forced arbitration can prevent the public from knowing the truth about issues, it means that the values of many different industries could be manipulated and seen as more valuable than they are. Would you agree with that?
I would agree.
Thank you very much.
The gentleman from Illinois, Mr. Foster, is recognized for 5 minutes.
Thank you, Madam Chair, and thank you to our panel. Mr. Gregg, as you know, some commentators have argued that public companies should be allowed to insert forced arbitration clauses in their bylaws, which would obviously prevent shareholders from suing the company in federal court for violations of the security laws, including securities fraud. It would also prevent shareholders from bringing class action suits against the company for securities fraud. And can you just tell us in general terms why it's important for shareholders to be able to join class action lawsuits against public companies? And secondly, could you give some examples of class action lawsuits for securities fraud that have been successful for shareholders?
Mm-hmm. So on your first question, it's important for 2 reasons. The first is that people, as Professor Coffey said, people are not going to go in it alone. They just won't. They don't understand the process. They sometimes won't receive any help because attorneys won't be able to represent them, because if you're cheated $100 or $200, that's a lot of money, but it's still not enough to hire a lawyer to go to court. So you're just going to let it go. You'll be angry, but you'll let it go. And number 2 is, especially in the securities context, this is hard. This is hard stuff. And being able to prove a material misstatement, intent to deceive, economic loss, causation, is not something that, number 1, you could do by yourself, and number 2 is oftentimes it's something that you'll need help from experts and potentially forensic accountants. So this is not something that you can do on your own. And then to your second question, as I mentioned earlier, WorldCom, Tyco, Enron, these were significant returns for cheated investors.
Could you say a little bit about the relative effectiveness of arbitration versus a court proceeding as a deterrent, both because the difference in how the results may end up being public, as well as the ultimate result?
Well, that's a good question, and one thing that I do mention in my testimony, if something is in arbitration, well, there are 2 things here. If it's in arbitration, number 1, we're not able to follow we won't know the development of the law. There will be no development of the law because arbitrators aren't bound by the law. So, especially in the securities context, this would be particularly harmful if we don't have development of the law. And then number 2, since so much of this is secretive, and a lot of times there are gag clauses, someone can be suffering the same harm in the next office, the next cubicle, the next door, and they will never know because you are prevented from even talking about it.
Right, and so that a crime could be committed by your neighbor, they could be appropriately punished for that crime, and you'd never know about it, and so you wouldn't be aware and avoid that behavior yourself. And it's Ms. Lubin, can you tell us why it is important that Main Street investors have the right to bring a private enforcement action if we have public enforcement by federal agencies?
Thank you for the question. I can say as a regulator for my entire career, we can't be everywhere. In a lot of ways, it's like being a mom. It takes a village, and you need a lot of people to keep an eye on what's going on. So you want the regulators, but the regulators, we have our regulatory interest in stopping bad behavior and moving on to another case, and that doesn't always involve restitution. If you look at the numbers that the SEC's recovered through fair fund actions, they pale in comparison through what's been recovered for investors through private actions. So it's really a 3-legged stool. It's the SEC, it's the state securities regulators, and it's private enforcement. And we have to make sure that private enforcement has the option of going to court, going to arbitration, and let investors decide. It really depends on the nature of the case for a customer to decide with their attorney which form do they want to select. But they shouldn't be locked in the beginning to having to only go to arbitration.
Yeah, and this issue of the having the choice, the name of the bill, if you, for example, if you're very interested in getting a rapid resolution of your case and you believe that arbitration will be faster, you have that choice under this legislation. I think that's a very fundamental point to be made here.
I agree. It's important that they have the choice, and frankly, I've seen a lot of cases that lawyers don't want to go near, that somebody could probably have gone into small claims court if they didn't sign a pre-dispute arbitration clause in their customer agreement, and that way that's inexpensive. You could do it yourself. Sometimes they're very clear-cut cases, and it gets resolved very quickly.
Thank you. I'm basically out of time here and yield back.
The gentleman from Ohio, Mr. Davidson, is recognized for 5 minutes.
Thank you. Thank you all for thoughtful comments on this. And, you know, Mr. Quadman, as I was looking through your remarks and things that you highlighted about the decline in IPOs, things that you highlighted about how accredited investors have benefited, you know, I would say disproportionately from the tech bubbles, the tech craze, and the things that haven't proved to be bubbles at all that have been enduring, whether it's been on the way up, knowing when to get down, knowing how to participate. And I think about the nature of an accredited investor. This is someone who's already wealthy, already, you know, the criteria isn't knowledge. The criteria is the possession of wealth, primarily. And so as I listen to colleagues repeatedly talk about, you know, the giant gap in income, in inequality, I think back to the fall. And in September, we hosted a roundtable for the ICO market. How do we deal with the right way to regulate what has been abusive, has been fraudulent, has been asymmetry of information at times in the ICO market, but what is dying for lack of regulatory certainty. And we heard from investors who were at the top of the food chain on skill, knowledge, and wealth, venture firms like Andreessen Horowitz. But we heard from early stage venture folks, and one of them pulled me to the side and they said, why did Republicans lock out regular people like me from deals? Why do they protect their rich investor buddies? And they were referring to the accredited investor rules, to this person who was a political novice, just trying to be part of an early stage company, writing code for a program, frustrated with the fact that he couldn't participate. He wasn't, although he helped write the code for it, he doesn't meet the accredited investor rules. And his perception was that the rich Republicans were doing stuff for their rich Wall Street buddies. And I tried to explain it. This is actually counterintuitive. Democratic access to capital, like so many other things that are out there in the false narrative, is actually a Republican idea. The idea that markets are for everyone, not just the special people. And he was shocked. It's like, well, this like starts to chip away at his worldview. And I said, you know, if you look at it, a number of other issues, you'll probably conclude the same thing. I'm certain he and I will not agree on all things, but that's one that that's there. Could you comment about how accredited investors have been the disproportionate beneficiaries of our current structure?
Sure. So number one, just to make a point that was made earlier, the decline in IPO, the decline in number of public companies actually started in 1996, 4 years before the tech bubble burst. But to your point, and there was an earlier discussion here, and when there was a discussion about all these different vehicles, there were vehicles that only accredited investors could use, right? And we have very specific income and asset levels of which people can invest in. And what we've effectively done over the last 20 years is to start to create a closed system where the accredited investors get the benefits of certain deals or whatever, and that the retail investor is not able to access that, which is why I was talking earlier about the decline or disappearance of the smaller IPO. Now, one of the things that the Jobs Act 3.0 did last year was actually start to modify some of the definitions of the accredited investor rules, where you actually start to allow for certain levels of education, experience, expertise, that they can start to maybe avail themselves of some of that, which I think is one way to start to solve some of it, but we do need to also deal with the other macro issues as well to help the retail investors.
Yeah, thank you for that, and thanks for the expertise you've lent to it. French Hill has certainly been a champion for that on our side of the aisle. David Schweikert, who's now in Ways and Means, and would love to have a collaborative, nonpartisan way to make sure that all Americans have access to our capital markets. I mean, really, historically, that's a big part of why capital has flourished in the United States. And unfortunately, you do see this concentration of wealth in hedge funds, and the narrative of ideology is not monolithic. There are folks with all political persuasions, but the reality is there are Main Street investors, people with retirement funds, pension funds, that are being locked out of access to these deals, and I think it's an incredibly important reform that we need to get done to make sure that our markets function. Absolutely protect consumers, full disclosure, but
full democratic access to capital. My time has expired, and I yield.
The gentlewoman from California, Ms. Porter, is recognized for 5 minutes.
Mr. Quadman, I've noticed that the Chamber of Commerce is fairly active, and in fact is quite active with litigation. It has an entire center devoted to litigation, and the Chamber sues the government on a regular basis. 5 times in the last 30 days alone has filed suits in the U.S. courts. In all of the cases that the Chamber has brought, are you aware of any in which the Chamber has appeared before arbitration panels?
I would have to check with our litigation center on that. I'm not aware of that, but I would have to check with them. But let me also say, too, with the cases that we do file, we are following what the law allows us to do, and we tend to win.
You tend to win in court?
Yes. But as I said, I don't know.
Because that's where you choose to file.
That's where
as
the law,
plaintiff.
that's where the law allows us to file.
Okay.
But we're suing the government. I don't know of any instance under the sovereignty laws if the government actually allows for arbitration in cases where there's a dispute with
Correct,
the government.
but the Chamber is also an intervener in private plaintiff suits. So my question is,
I don't know. I would have to check with the litigation center. I don't know if we are an intervener in private plaintiff suits. We actually sue the government.
yes, but okay, got it. My question
Which doesn't allow
is,
arbitration.
Correct. Why do you think that is?
Why the government doesn't allow for arbitration?
Yeah.
I don't know. I would have to check the history on that.
When the Chamber sues the government, does it expect the judges to follow the law?
Of course.
Do people who have their grievances heard in arbitration, can they count on the arbitrator to follow the law?
An arbitrator is supposed to be fair. If an arbitrator is not fair,
I'm just asking, can they count on the arbitrator to follow the law?
They should, and if they're not, they can go to court to actually overturn the award and actually to take the arbitrator off the case.
Mr. Gregg, would you like to respond to that?
I respectfully disagree. There is no requirement to follow law or precedent, and in fact, the requirements for appeal are very, very limited. In fact, Justice Kagan said that in several Supreme Court cases, and simply getting it wrong, the Supreme Court has said, is not enough.
It's not enough. Mr. Quadman, do you think that the development of law is important to, and certainty of law is important to allowing companies to make decisions about their capital structure?
I would say in terms of a capital structure for the company and for the capital markets, you know, the companies are going to follow what Congress dictates, what the SEC is coming out with in terms of rules.
Let me ask it another way.
Yeah.
Is legal uncertainty, is uncertainty about the legal standard positive for the business community?
Well, I think we're talking about apples and oranges here because legal uncertainty does create problems, and it creates problems not only for businesses, it creates problems for consumers as well. But what I would say with arbitration, arbitration allows for a speedy redress of grievances, and as we talked about earlier with the FINRA arbitration process, number one, there's a fairly high rate of where investors are winning their cases, and there's also a very high rate where there are settlements of cases before it even goes to the arbitrator, and that is much faster than when if this was just allowed to go to court.
Mr. Gregg, would you like to respond?
I would. One significant problem is uncompensated awards in FINRA. In fact, Senator Warren and Senator Kennedy have introduced last Congress a bill to help people who were in FINRA actually get the awards that they never have gotten.
I yield the remainder of my time.
Gentleman from Texas, Mr. Green, who is also the chair of the Subcommittee on Oversight and Investigations, is recognized for 5 minutes.
Thank you very much, Mr. Chairman, and I thank the committee for allowing me to interlope today. I'm not a part of this subcommittee, but I am very much concerned about the ruling of the Supreme Court in 2018 in a case styled Digital Realty Trust versus Summers. In that case, the court held that the protections against retaliation in Section 922 of Dodd-Frank are not applicable to persons who report these egregious offenses to their employers. This hearing affords us an opportunity to rectify and to adjust the law such that justice can prevail. It is my belief that we should allow these protections for those who report to their employers. So let me start, if I may, with a lawyer par excellence. Mr. Gregg, you're considered a strategic thinker. Can you kindly tell me at this time, what do you think about this legislation that we have proposed and the Supreme Court's decision to a very limited extent, because I do have a second question?
Thank you for the question, Congressman. We do support the legislation. The Supreme Court actually got it right. The language is very clear in the statute, and that's why Congress must act. And that's why Senator Grassley, for example, in his amicus brief in Digital Trust, basically said the same thing that you're saying. There are a lot of protections in the Dodd-Frank rule, the Dodd-Frank law for anti-retaliation that is not in Sarbanes-Oxley, and that's why we need to have this, this law.
Ms. Lubin, if I may, you have a reputation for justice and fairness. Give me your thoughts, if you would, please, on whether this would, if not implemented, have an adverse impact on reporting by employees.
Well, thank you for the question and for the compliment. I think it would have a very adverse effect because it's a chilling effect. The employees are not going to come forward when they're faced with a balance, am I going to lose my job or am I going to try and fix what's going on in the company, because they'll figure whatever's wrong is somebody else's problem. So there won't be reporting. The companies won't have the opportunity to fix it before it becomes a very big deal, which is something that'll be lost if the whistleblower, so to speak, doesn't know that they're going, you know, that they will be protected if they go ahead and tell, you know, management that something adverse is going on. So I think it's very important that we, you know, that the legislation encompasses taking care of employees if they whistleblow internally and not just to the SEC.
Thank you very much. Professor Coffey, thank you for your service and being here today. I thank all of the witnesses for being here today. I may not get to question all of you, but I do thank you for coming. I'm interested in your commentary on this question.
I think it is imperative that Congress reverse digital realty. It was probably correct on the statutory structure, but this is not a constitutional decision. The statute didn't recognize how this could get, in effect, perverted. And actually, the irony here is that most of the business community wants employees to report internally, and because of this decision, employees represented by counsel will never report internally. It's probably better if you have protection from full protection under Dodd-Frank, that you go first to the company, because things can get worked out cheaply, easily, and effectively. So we've come up with an outcome here that injures employees and does not benefit corporations, because corporations find that they will no longer get any internal reporting. No one wins under this outcome, and thus I think it's imperative that Congress reverse it.
Well, thank you. And if I may, I'll thank all of my colleagues who have indicated that they'll be supportive of this legislation. It's my hope that we'll get it passed. And Mr. Chair, excuse me, I yield back the balance of my time.
Now a minor piece of housekeeping. Without objection, the article that I submitted when I was not sitting in this chair, for the record, is so ordered. And I wanted to recognize the ranking member, who I understand you have some documents to submit as well.
Thank you, Mr. Chairman. Yes, and without objection, I'd like to submit a testimony from the Securities Industry and Financial Markets Association, SIFMA, as well as a letter from the Small Business and Entrepreneurship Council.
Without objection, so ordered. And before we wrap up, I would like to take care of one other administrative matter. Without objection, I'd like to submit letters and statements for the record from the American Association for Justice, and the Public Investors Arbitration Bar Association. I'd like to very much thank our witnesses for their testimony and time today. And without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will be forwarded to the witnesses for their response. I would ask our witnesses to please respond as promptly as you are able. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion of the record. And this hearing is now adjourned.